Hello class, my name is Carson Tank. I will be doing my presentation on the Supreme Court known as the Marshall Court. Now this was the fourth Supreme Court bench of the United States, and it was from 1801 to 1835, and this court is considered by many historians to be the most impactful court on today's federal government and the role and shape of it. So the judicial philosophy of the court was very different than the idea of the nation at the time. So the nation was moving in a more agrarian, democratic, republican stance, and these guys were old, leftover Federalists from the Adams and the Washington administration. And what that means is these Federalists, five of the seven were committed Federalists. They really favored a strong central government, a powerful army and a navy. They favored the merchant, the wealthy, the upper class, and these guys are considered the big government, that sort of stuff. They really used the elastic clause. So what that meant is they believed that anything that was necessary or proper to making laws, or that Congress had the ability to do, they were going to support that and stand by it and very loosely allow the constitutional interpretation. Now, the first major decision was the Marbury versus Madison. So basically, what this was when John Adams left office, he attempted to pack the courts with as many Federalists, remember, that's the government, pro government political party, as he could to kind of leave his legacy and leave his mark. And he had actually just lost the race to Thomas Jefferson at the time, so he was very bitter and resentful. So his Secretary of State at the time, who was James Madison, he got these letters and he said, instead of making them published and going through with these appointments, I'm just going to hide them in my mailroom uh, and hope that nothing bad happens and that we can delay these for as long as possible. Now, it's important to remember that these letters that James Madison is holding, they're largely ceremonial letters. They already have the job. So I think back to when Mike Pence was called on to certify the election on January 6th of this year, and he certified it, but many really far right Republicans said, don't certify it, see what happens. Vice President Pence certified the election. And essentially the decision was um, a mandamus, which was basically the concept that this guy could go through. Uh, Marshall said it will not be granted, but he wanted to input his own judicial philosophy in there, and he said basically that I'm not going to grant this, but I'm going to give myself and the court a lot of power. So, previous to Marbury versus Madison, the role of the judicial branch was contained in a Judiciary Act of 1970 or 1789. And that Judiciary Act, passed by Congress, defined very specific things the judicial branch could and could not do. And Marbury versus Madison, he said, uh, I am going to make the judicial branch able to interpret laws of Congress and of the executive branch. And this made the judicial branch an equal branch among the three different branches, which was quite huge. This is considered by many scholars to be the most important court case in United States history because it defined the three branches we know today. So that is the first case, Marbury versus Madison. And yeah, it was a little dispute over some paperwork, but it ended up with the court being its own branch. And unfortunately, Marbury never got his appointment, and that just got lost in the legal paperwork. So I feel bad for Marbury for not getting his appointment. The next giant case of this court was McCulloch versus Maryland. And essentially at this time, the Federalists, remember the pro government, pro centralized government political party, they had established a national bank under Alexander Hamilton, and they placed this national bank in the state of Maryland. And Maryland, they are considered a southern state and a more democratic Republican state, and they do not like the idea of a national bank imposing on their right to bank themselves. They didn't like the concept Hamilton had of the federal government assuming states' debts. So Maryland, because they were so mad at this federal intrusion, they said, hey, we're just going to tax the bank. And I believe the tax was $15,000 on the bank, which to us, that's like, okay, that's a car. But back then, that was the equivalent of millions of dollars of today. So this was huge. And because the Marshall Court was keeping with the theme of being a federalist and increasing the size and scope of the government, McCulloch won. And they argued that the supremacy clause in the Constitution, which I believe is in Article 1, says that the federal government always reigns supreme when there is a dispute among the states. So if we look back to in this time it was a bank, but today that could be considered the marijuana laws and the concept that although states can pass their own laws regarding substance, if there's ever a conflict, the federal government should have the right of way on this. They also said having a bank is necessary and proper to tax its different citizens, and that it is the federal government's job to tax citizens, to raise revenues, to raise army, and stuff like that. So this was kind of in the middle of Marshall's reign, and it again, just like Marbury versus Madison, McCulloch versus Maryland opened the door for a expansive federal government. Here we have a political cartoon, and on the bench we have a justice, probably Mr. Marshall, Justice Marshall, saying that establishing a national bank was necessary and proper because they had to tax. And we've got poor little Maryland over here saying that's why we wanted to stop it. We are not a fan of these taxes. So that's the second case. Yeah. The third and final case is called Gibbons versus Ogden. Now, this is another landmark case, the third and final one, and it is a little bit complicated, so you're going to have to bear with me. So essentially, back in the day, if you wanted to get around New York or New Jersey, you couldn't drive. There was a lot of water. You couldn't really take a horse because there weren't bridges made everywhere. So the way you could move around New York and New Jersey was by these steamships. And there were two big steamship companies competing at the time. There was a man, Mr. Gibbons, Gibbons Ferry, and Mr. Ogden, Ogden Ferry. And Ogden was the larger of the two. And Gibbons is like, I don't like this. Ogden's bigger than me. And is there any way that I can beat Ogden in business? And he looked at this emerging federal government at the time and the Federalist movement. He said, I'm going to capture on that and I'm going to get Gibbons said, I'm going to get a federal license so that my license is legit. And Ogden is just going to have to park his boat and I'm going to put Ogden out of business. So it followed the steps. So it went to a smaller court. And what happened at that smaller court is they ruled in Ogden's favor. They said, hey, he has a New York state permit. He's good to go. Gibbons was still very mad because he wanted this government monopoly. So he went to the next level, the second court. I believe it was appellate. And the appellate court said, yeah, we're going to have to side with Ogden again. And so finally, it made its way up to the Supreme Court. And mind you, five of these seven justices were committed to expanding the size and scope of the government and creating one national centralized government rather than separate state governments. So the court decided that Article 1, Section 8 gave them the power to regulate all interstate trade under the Interstate Commerce Clause. So remember, New York and New Jersey, they're right next to each other, but because they're both two states, when they're two states, the parent, the federal government, gets involved. So Gibbons won, and many critics or Democratic Republicans at the time said this is the birth of government monopolies, such as what we see today in utility companies and other cell towers and other things that are backed by the federal government that don't allow somebody smaller to undercut prices. Now, in my opinion, I think they could have just shared the river, but hey, we like to sue in America. Now, like all the other cases, the case itself wasn't super important. It was the precedent that was set by the case. So the precedent was called the Commerce Clause, which is enumerated in Article 1, Section 8. And here on the graphic, we have a map of all of the different businesses in America, the largest of each state. So in Michigan, we have General Motors. Iowa, we have Maytag, the appliance company. Nebraska, Cabela's. California, Apple. North Carolina, Bank of America. And I want to talk about Bank of America. So because Bank of America does business in all 50 states, the federal government says, hey, because of that, and Dodd-Frank and some other things, which I might talk about later, because of that, I can regulate you. Not the state, the federal government can because you do business. And this allowed for what I call the bureaucracy state, in which the federal government can monitor all private businesses, financial operations, uh, if they do business in other states. Now, at the time, if you were just doing business in your own state, which was pretty common at the time, you were protected from the federal government prying into your private business and stuff like that. So if you were just a merchant and you did business in Boston, you were okay. Now, the other thing moving forward with commerce is big tech. We have in the corner of this graphic Google, Facebook, Twitter. They float around all 50 states. So under Article 1, Section 8, they could be subject to congressional auditing, financial reports, privacy laws, anything the federal government deems. And that brings me to the conclusion of my presentation. So again, three different cases. We have Marbury versus Madison, which established judicial review. McCulloch versus Maryland, which flexed the supremacy clause. And it was kind of a strange lawsuit because, Maryland is like the kid trying to tax its parent. If I'm at home and I said, hey, mom, I'm going to tax you, she'd probably laugh at me. So that was a very well respected decision, but the clause that came out of it was quite big. And then the Commerce Clause, we end with Gibbons versus Ogden in the Commerce Clause, which allows the federal government to track commerce from state to state. So the biggest thing with this court, it is important to remember that the political sentiment at the time, the wind was blowing in the favor of the Democratic Republicans and the more limited government Jefferson, Madison, Andrew Jackson. And the only reason these Federalist big government policies could happen is because they were appointed under Adams and Washington, but their legacy lived on another 30 plus years from that. And I want to end with this concept of Jacksonian democracy. So, unlike federalism, which said, let's let the federal government be as big as possible because we can improve efficiency, a military veteran by the name of Andrew Jackson came along and he said, I'm going to stop the bureaucracy. I'm going to stop the national bank at the time, which was McCulloch versus Maryland, which I talked about. And he said, I'm going to end it all and return to a uh, agricultural state where not just the merchants and wealthy win, but the farmers and other people win. And that brings me to my final slide where we have Andrew Jackson at the White House. And rather than merchants in the White House doing parties and various things, it's the common folk, the farmers, the Masons, and everybody out there that is celebrating his presidency, where he is ending this popular sovereignty. And because of this political Jacksonian democracy movement, you had the Federalists lose all power, and he began appointing justices, which then began to make very different decisions from the Marshall Court. And that concludes my presentation. For my works cited, I used the National Archives for a lot of things. I found them to be very helpful with different summaries. I used the State Department. I used the Library of Congress for some political cartoons. And then my JSTOR citation is in the top. That's a Marbury versus Madison citation. So I hope you enjoyed my presentation. Thank you very much.